you might have covered a lot of this in the materials, but again, if we could just maybe drill down a little bit more or go back to it. But one of our attendees wanting to know, basically, what factors would you say should be considered when choosing a law firm to represent you in a cross-border asset recovery case? What are those factors to be looking at when choosing that firm?
When choosing a firm, first since we're talking about first asset recovery, you want to look into the experience, the team that is in place for asset recovery. But then, as you're talking about cross-border asset recovery, you want to make sure that the firm representing you has those international experiences and capabilities and an international team of lawyers and investigators who can assist you in your U.S. efforts, for example, but that also feels comfortable in navigating other jurisdictions, and that is, of course, experience in the different tools available for asset recovery, depending on the nature of the fraud or the other wrongful conduct that you are facing. So, for example, when you're dealing with crypto matters, you want to make sure that you're selecting a team of lawyers and investigators that, based on their experiences, have had the opportunity to work in that type of cases. And the same with any other type of crime or wrongful conduct that led to the assets being stolen, call it corruption, fraud, money laundering. So to me, the two key factors are experience and pick a good team, not only experience, but with the international reach to represent you in these cross-border asset matters.
Thank you so much. Another question. I think we have time for this one here. What are the advantages and disadvantages of using alternate fee agreements and third-party litigation funding to finance legal actions for the recovery of stolen assets?
The advantages, and we talk a little bit about this during the presentation, is because these matters, these asset recovery matters, are often complex. They involve different jurisdictions. They involve review of several documents, records, and tracing of the assets, and going back and investigating what happened. That requires time. That requires time, efforts, a good team in place, and that can get expensive, just because that's how things are, and especially in the U.S. context, that's the nature of these representations, and that puts victims and plaintiffs sometimes in a difficult position because they have lost already money, funds, an asset, but then for purposes of recovering that asset, they also need to incur in substantial expenses and costs, legal expenses and costs, for them to be able to have an opportunity to recover the asset or conduct efforts to do so. So this third party litigation funding, as well as these alternative agreements, sometimes for victims, especially individuals that never expected to be in this position and that never expected to incur in these expenses, are a good option for them to be able to get the necessary funds for them to afford litigation. So sometimes it's actually the best option for them to be able to pursue legal actions, just because they don't have the necessary funding to do it. So they are placed in a situation where the victim or the plaintiff either gets into one of these agreements or gets third party litigation funding, or there's just a loss, right? And the costs of the litigation or the other legal efforts are just going to be too high to incur for a plaintiff or a victim. So especially for individuals, but hey, even we have seen this in practice. Even companies and firms find these agreements and third-party funding attractive to cover these legal efforts. So that's I guess the advantage and the logic behind the agreements and the third-party funding.